Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. I am Michelle Itkowitz, and today we are discussing pets and emotional support animals in New York City no pets buildings. This is part 1 on pets. Part 2 will be on emotional support animals. If you're interested in emotional support animals, you need to listen to this episode first, because this episode lays the foundation you need for the emotional support animal part. Before I started this podcast, I worked on a project where I was creating on-demand online classes for New York City tenants so they could learn about the laws that affect their apartments. That work was honestly some of my best stuff, but I just wasn't reaching enough people, and I pivoted away from that project and started the podcast. The difference between one of my on-demand online classes and a podcast episode is that the classes were longer. They were more structured, and the classes had a video component. The video was not of me, but of slides that illustrated the material I was teaching. Today, I'm going to do an experiment and embed half of the pets and emotional support animal class into this podcast. And you may notice, if you're on YouTube or Spotify, this will be the first episode of the podcast with a video component. So I'm excited to share this material with you, but I'm also curious to see if this growing audience likes having a video slide deck component to the podcast. Everything you read these days on podcasting insists that video podcasts are more popular than exclusively audio podcasts. Personally, I never watch a podcast. I like the audio-only format because I consume podcasts while I'm doing other things. If I'm loading the dishwasher, folding the clothes, watering the garden, whatever it is, I'm listening. But that might just be me. So I'm going to put up a poll and ask if you would like to see a video slide deck aspect to this podcast on a more regular basis. By the way, for people who only want to listen, it should be fine for you as well, but let me know. One more thing, the class was recorded a while ago before I was podcasting, and I had the Riverside FM technology to record with. So back then I had no way to filter out sirens. I wasn't then, and I'm not now, in a studio with a team. I'm at my desk with my cats. So I apologize in advance for the quality of the class audio. Hopefully the quality of the content makes up for it. In the class, I mention a book. The class came with a 36-page booklet. I'll put a link to the booklet in the show notes. Of course, it's free. Okay, here we go with part 1 of the class, Pets and Emotional Support Animals in New York City No Pets Buildings. All right, so we're starting with pets. Cracking the code on pets in New York City apartment buildings. Every tenancy is governed by 3 things. It's, first of all, governed by the lease. The lease is the contract between the landlord and the tenant. And whenever a tenant calls me up, the first thing I ask them for is, send me the lease, send me the lease, send me the lease. And by the lease, I don't just mean a few pages of it. The whole lease, including any riders, any attachments, and then, of course, any renewals, modifications. All these documents together form the lease, and they are all important because this is what governs the relationship between the landlord and the tenant. And then, of course, we have statutes, applicable laws. Laws are made by the legislatures. We have the city council here in New York City, and then we also have the legislature in Albany, and that makes laws that govern New York City tenancies as well. And of course, there are also some federal laws. Sometimes the laws, the statutes, conflict with the lease. Usually when that happens, the statute trumps the lease. And we're going to cover that a little bit in a minute on this pet topic. And then, of course, very importantly, we have cases. cases that interpret how the lease and the statutes are going to work. If a landlord and tenant have a dispute and they go to a court and the judge makes the decision and writes it up and it's published where decisions are published, that case law becomes part of the body of the law, and it guides us because it lets us know how certain situations are going to work out, and we depend on that heavily, and we're going to cover that here. You'll see what I mean. First, we're going to start with the lease. I have here now on the screen 2 clauses that I pulled out of actual leases in my files from old cases, and both of these sections were in the actual body of a lease, the actual main printed form. One section called itself Animals and says tenant shall be entitled to keep no more than 0 domestic dogs, cats, or birds. So that's one way of doing it. And then in this other lease, section M says no pets. Animals of any kind shall not be kept or harbored in the apartment unless in each instance it is expressly permitted in writing in advance by the landlord, or if otherwise permitted by law, and then talks about if permission is granted, the dog will be on a leash. These 2 sections were found actually in the lease. Then these next 2 sections I found in riders to the lease. A lot of times you'll have your printed lease and you sign on the bottom, and then there are extra pages and an extra signature pages because the landlord is adding things particular for their building or for things, extra things they think they want in the lease. This one had no pets allowed in the apartment. And then here we see a longer one here. And then finally, I found this big long one in the rules and regulations of a lease. Many leases will say they'll have a provision that says tenant promises to follow the rules and regulations. And the rules and regulations are another paper attached to the lease. That's where I found this no pets clause. The takeaway here is that pet clauses can look very different depending on what lease they're in, and they can be in any section of the lease. You have to keep your eye out for this. So your step 1 is going to your lease, your whole lease, and looking through it. And that includes, again, renewals and extensions, because sometimes landlords will stick new terms in there as their policies change. You want to look at your whole lease. Now, you might be saying to yourself, Michelle, why you're telling us to look at the lease and find this bad news, whether it's animals, no pets, however it's phrased, why are we looking up the bad news? Because I'll tell you why. It might not be bad news. I think it was on my 7th or 8th try, just working backwards through my files, looking at lease clauses, when I found this clause. It looks a lot like the clauses we saw on the previous slide, all of which were different versions of bad news telling the tenant that the tenant was prohibited from having pets. But let's read this one. The tenant shall be allowed to have three pets on the premises, consisting of birds, cats, dogs, fish, hamsters. If a tenant calls me up and they believe that they are in a no pets building, and the first thing I say to them is, show me the lease, show me the lease, show me the lease, all parts of the lease, and we read it, okay, problem solved. These people may have 3 pets. Now, the takeaway really is you have to start with your lease. That's why we've spent this time on this. Now, what if your lease is silent? What if your lease doesn't say anything? It's not pro pets, it's not con pets, it doesn't mention pets. In that case, if the lease is silent, if your lease does not prohibit pets, then you may have pets. I have the legal citation for this concept on page 7 of your booklet. Everything I'm saying during these slides is backed up in your booklet with a legal citation. Okay, now we're going to move on to statutes, which is the much more tricky part of our program. All right, next we need to talk about the more common situation, which is your lease says that you can't have a pet. So it's a no pets building. We have something in New York City called the 3-month rule. And that's located in the New York City Administrative Code, and it's entitled Rights and Responsibilities of Owners and Tenants in Relation to Pets. Over here, I have the beginning of the law. I know I have a lot of words over there on the right side of the page. This is the legislative declaration that's at the beginning of the law passed by the City Council, and it explains to us why the City Council made the rule. And I think if we understand why a rule was made, it helps us understand the rule even better. I would just like to share this with you so you see the sentiment of what's going on. I'm just going to do just a little bit of reading here. The council hereby finds that the enforcement of covenants contained in multiple dwelling leases, which prohibit the harboring of household pets, has led to widespread abuses by building owners or their agents who, knowing that a tenant has a pet for an extended period of time, seek to evict the tenant and/or his pet, often for reasons unrelated to the creation of a nuisance. Because household pets are kept for reasons of safety and companionship and under the existence of a continuing housing emergency, and we certainly still have one of those going on, it is necessary to protect pet owners from retaliatory eviction and to safeguard the health, safety, and welfare of tenants who harbor pets under the circumstances provided herein. It is hereby found that the enactment of the provisions of this section is necessary to prevent potential hardship and dislocation of tenants within this city. What they had going on when this law was created was probably there were tenants in undervalued leases and landlords wanted them to leave so they could charge more rent, and they were looking for an excuse, and they said, oh, look at this in my old dusty lease, I have a no pets clause, and I know that this tenant has a pet. They would bring an eviction on that basis, and it really wasn't fair to people, thus they passed this law. Now let's talk about who the 3-month rule, as we're going to call it, who the 3-month rule covers and what exactly it says. As per the 3-month rule, when it comes to pets in New York City, the law trumps the lease. Remember, we started talking about that. That's very important because you can hunt through your lease and see no pets, no pets, no pets. Again, I'm having you hunt through your lease because maybe it doesn't say anything about pets, in which case you can have a pet. Or maybe it says you can have a pet. But if you can't have a pet, then we start talking about the 3-month rule. Because this law will overcome anything that your lease says. The law has priority over the lease. Thus, even if your lease contains a no pet clause, your pet can remain in your apartment if, now let's go through the ifs. If you live in a building with 3 or more apartments. In New York City, any building with 3 or more apartments is known as a multiple dwelling. This 3-month rule only applies to anybody living in a building with 3 or more units. As I said in the advertisement for the class, this class has somewhat less to offer for someone living in renting from in a 2-family home or renting an entire house. This is for 3 or more units. If the pet is not otherwise illegal to own, it has to be a legal pet. And the landlord knows or should know about the pet in your apartment. Now, what does that mean? The landlord knows or should know about the pet. You adopted a cat at the shelter and brought it home. Does the landlord know about that? You didn't tell him? We're going to go into that in a minute. That's where we need our case law to explain how the statute plays out. From the time the landlord knows or should have known, which we're going to examine in a minute, then 3 months goes by without the landlord doing what? Without the landlord bringing a summary proceeding. A summary proceeding is another name for a housing court case. It's referring to special proceedings pursuant to the Real Property Actions and Proceedings Law. If 3 months goes by from the time that the landlord knew or should have known and the landlord doesn't bring a housing court case, that is going to overcome the no pets clause in your lease. Also, it's another requirement is that the pet is not a pet who causes damage to the apartment or creates a nuisance or interferes substantially with the health, safety, and welfare of other tenants. That part is very important. And we'll get to that in a minute also. It's important to drill down a little bit more on who the 3-month rule applies to. We already talked about the multiple dwelling aspect. The 3-month rule also does, yes, apply to residential cooperatives. It does not apply if you live in a condominium. Now, remember again, the 3-month rule, it doesn't apply if you're renting a single family home or one of the apartments in a 2-family home. And the 3-month rule also does not apply to NYCHA, to apartments in the New York City Housing Authority. Okay, now we are going to focus on that confusing part of the law about the 3 months that is so important. It starts running from the time that the owner has knowledge of the pet or should have knowledge of the pet. And it's the tenant's burden to prove that the landlord obtained knowledge. Again, you adopt a cat at the shelter and you go home and you didn't tell your landlord about it. The landlord doesn't know, the 3 months isn't running. You have a dog, you're walking your dog, but you didn't tell the landlord. Is the 3 months running? Every law has its place where there's a lot of controversy over that little issue of the law. And this is it for the pet law and the 3-month rule. Now we're going to look at how the cases interpret the law. All right. The case law tells us that maintenance staff, porters, and security guards, doormen, repair people, all of these people are agents of the landlord within the meaning of the 3-month rule. If these people know you have a pet, then the law deems that the landlord knows about the pet. So if, for example, a repair person comes in to fix your window, and maybe the cat runs and hides under the bed. They don't see the cat, but there's the litter box in the bathroom and they're fixing the window in the bathroom, and they walk through the kitchen and there's water and food bowls there. The repair person didn't see the cat, but that's enough for you to satisfy the open and notorious requirement of the statute that shows that they have knowledge of the cat. And that repairman may not be an officer of the landlord corporation, but he's an agent and his knowledge is imputed to the landlord. That situation would be enough to start the clock running on the 3-month rule. Here's another case. If a dog is walked through the common hallways and outside of the building twice per day, as every dog is, this satisfies the open and notorious requirement for triggering the clock on the 3-month rule. So a little bit easier with dogs than with cats. If the landlord sends the tenant a letter, an email, a note, or a text about a pet being unauthorized, this is also really excellent evidence that the landlord knows. Now, let me just say this about this line of case law. It's very scary to get that letter from your landlord that says you have a pet and you're not supposed to. But the silver lining of it is it solidly establishes the landlord's knowledge. Now, that clock might have already been running. Again, the repairman might have come in and seen evidence of the cat. So your 3-month clock might already be running, but if for some reason it wasn't, it is now, because the landlord has established clearly they knew. If you don't get sued within 3 months of that note, then the landlord is deemed to have waived the no pet provision of the lease. To drill down a little, there's one case where, if the superintendent is walking up to your dog and petting it and saying, hey, Charlotte, it's great to see you today, and giving the dog a treat or something, this kind of detail is a good thing to keep in your mind to remember. Whenever I see Susan, the porter, she's always petting my dog. Other things, it also doesn't hurt to take pictures of you walking your dog through the lobby if you think you're going to have a problem. And if you have neighbors who will be good enough to testify on your behalf, that's a very important thing to keep in mind, very helpful. And if the building has security cameras, even if there's not a doorman and you're taking the dog in and out and there's a camera in the common areas, well, that's imputed to the landlord as knowledge as well. Finally, case law also suggests that you should save all the information that documents the date you adopted your pet, because this might help prove when the 3-month rule began running. Now we're going to really look at the text of one of the cases just to kind of just to make sure you have a super real life example of what a court might consider. These words here from this case from 2015 are from a judge writing a decision. And this is what the judge observed when holding for the tenant and saying that the landlord had waived the no pets clause of the lease. Let's look at this. Tenant treats Duchess the dog like her own child. Duchess is often dressed up and always on a leash when walked. Photos of Duchess in the common areas of the building on various dates in all different outfits and with different bows for her hair were admitted into evidence as Exhibit A. Other witnesses credibly testified on Tenant's behalf that Duchess was frequently seen in front of the subject building, coming in and out of the building when being walked by respondent. Looks like everybody knew Duchess. There is a security guard stationed in the lobby of the building on weekends, and there are cameras in the lobby and elevator of the subject building. That's an example of how granular it gets in a courtroom when a tenant is trying to prove that the landlord had knowledge of the dog for purposes of running the 3-month rule and getting the no pets clause waived. These are the kind of things that you should be thinking about. There are 2 more things that we learned from cases on the 3-month rule. There is a possible downside of depending on the 3-month rule, and that's this. It's great that it's a very short period of time from the time that the landlord is imputed to have knowledge to the time they have to sue. It's only 3 months and you have your waiver. The problem is that savvy professional landlords understand this. And if they're serious about keeping a no pet building, it forces their hand to take legal action very quickly because they understand if they don't, then they're going to waive the no pets clause. So there's one case where a landlord became aware of an animal and started an eviction proceeding, but they screwed up the case somehow procedurally, just a technical problem, which is a big source of defenses in housing court. The case got dismissed on this technicality. Then the landlord went and started the case again. Then the court said, well, look, the landlord did not diligently pursue their rights because they screwed up the case. So I don't care that it was a technicality that caused them to be in court on this ultimately after 3 months. All I care is they didn't get in by 3 months. The no pet clause is waived. The courts are very strict about it. And like I said, savvy landlords understand that. So if you're depending on the 3-month rule and it's early in your adoption process, it can be very stressful waiting to see if you're going to suddenly end up in housing court. Also, the 3-month rule waiver is only a waiver that's applicable to the pet at the time the waiver happened. Pet or pets, I suppose, at the time the waiver happened. It doesn't apply to pets you get later, and it doesn't apply to a pet that you get after your pet passes away. That's sort of another downside of the 3-month waiver. It's not saying that you can always have pets. It's saying that you can have this particular pet. Other options. You, of course, always have the option to simply ask your landlord if you may have a pet. I am going to guess that the answer is probably going to be no. However, I've worked with lots of landlords that happily allow pets. It's not the majority of landlords out there, but they do exist. There are pet-loving landlords out there. Your other option is to just search for an apartment that does allow pets. It's already a very tight market, and this gives you a lot less options, but you do have these options. It just needs to be pointed out if you're approaching this topic holistically and looking at your whole life as a whole. I'm going to tell you a story. I got a call from a woman who was moving from California to New York City, and she was going to be moving into a no pets building The building had an elevator, but no door person. The issue was that she was planning on moving in with two 90-pound dogs. She was aware that it was a no pets building. She was clearly operating on the forgiveness, not permission plan. And she was all geared up to beat down the landlord with the rule. And she wanted my advice. Honestly, my advice in that particular situation was don't do it. Find another place. Because the problem I told her is in these situations, a lot of times people don't realize your real obstacle is not really the landlord. It's your neighbors. Your neighbors who live in a no pet building and who don't have pets. Most landlords are just happy to get the rent. So, but I told her the first time you get into the elevator, especially if it's one of those small elevators with your two 90-pound dogs and some neighbor who has a ton of groceries and the dogs are sniffing the bags, or, you're going to get a call from the landlord. And really, sometimes I see these situations and it's not exactly fair to the animals, because I feel like animals can sense when there's antipathy to them. And I've seen people set their animals up for failure. This is just a story to illustrate the issues that come up in this area. So consider that you have other options of asking for a pet or finding an apartment that allows pets. Okay, I hope you enjoyed the video. Again, let me know. The next episode will be the second half of the class, the emotional support animal part. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.